Transgender rights in the United States vary considerably by jurisdiction. In 2021, at least 117 bills were introduced in 33 states to restrict the rights of transgender people. The Supreme Court of the United States has only once ruled directly on transgender rights. In 2020, in the case of R.G. and G.R. Harris Funeral Homes Inc. v. Equal Employment Opportunity Commission, SCOTUS held that Title VII protections against sex discrimination in employment extend to transgender employees. The Equality Act, if passed, would prohibit discrimination on the basis of gender identity in employment, housing, public accommodations, education, federally funded programs, credit, and jury service. Some lawsuits argue that the Equal Protection Clause of the Federal Constitution or federal laws prohibiting discrimination based on gender should be interpreted to include transgender people and discrimination based on gender identity. U.S. President Barack Obama issued an executive order prohibiting discrimination against transgender people in employment by the federal government and its contractors. In 2016, the Departments of Education and Justice issued a letter to schools receiving federal funding that interpreted Title IX protection to apply to gender identity and transgender students, advising schools to use a student's preferred name and pronouns and to allow use of bathrooms and locker rooms of the student's gender identity. Recognition and protection against discrimination is provided by some state and local jurisdictions. To varying degrees, birth certificates are typically issued by the Vital Records Office of the state law. However, federal law regulates sex as listed on a consular report of birth abroad, and other federal documents that list sex or name, such as the U.S. passport and certificate of naturalization. Laws concerning name changes in U.S. jurisdictions are also a complex mix of federal and state rules. States vary in the extent to which they recognize transgender people's gender identities, often depending on the steps the person has taken in their transition, with some states making gender affirmation surgery a prerequisite of recognition. Non-binary or genderqueer people may seek legal recognition of a gender identity other than that indicated by their birth sex. In 2016, Oregon became the first state to legally recognize non-binary people. When a person's gender is not officially recognized, they may seek associated changes, such as to their legal name, including on their birth certificate. The SCOTUS decision in Obergefell v. Hodges established that equal protection requires all jurisdictions to recognize same-sex marriages, giving transgender people the right to marry regardless of whether their partners are legally considered to be same-sex or opposite sex. The Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act of 2009 added crimes motivated by a victim's actual or perceived gender, sexual orientation, gender identity, or disability to the federal definition of a hate crime. However, only some states and territories include gender identity in their hate crime laws. In Obergefell v. Hodges, SCOTUS ruled that people have a right to marry without regard to sex. While this is commonly understood as a ruling allowing same-sex marriage, it also meant that a person's sex, whether assigned at birth or recognized following transitioning, cannot be used to determine their eligibility to marry. Prior to this ruling, the right of transgender people to marry was often subject to legal challenge, as was the status of their marriages after transitioning, particularly in cases where an individual's birth sex was interpreted to mean a same-sex marriage had taken place. In 1959, Christine Jorgensen, a trans woman, was denied a marriage license by a clerk in New York City on the basis that her birth certificate listed her as male. Jorgensen did not pursue the matter in court. Later that year, Charlotte McLeod, another trans female who underwent sex reassignment surgery, married her husband Ralph H. Heidel in Miami. She did not mention her birth sex, however, or the fact she was still legally male. In 1976, the New Jersey case MTV JT held that trans people who had undergone sex reassignment surgery could marry as the legal sex matching their gender identity, the first ruling of its kind. Here the court expressly considered the English Corbett v. Corbett decision, but rejected its reasoning. In Littleton v. Prange, the court subsequently invalidated her revision to her birth certificate, as well as her Kentucky marriage license. Ruling, we hold, as a matter of law, that Christy Littleton is a male. As a male, Christy cannot be married to another male. Her marriage to Jonathan was invalid, and she cannot bring a cause of action as his surviving spouse. She appealed to SCOTUS but it denied certiorari in 2000. The Kansas Appellate Court ruling in re estate of Gardner considered and rejected